Most sellers spend months preparing for their home sale. They clean, they stage, they interview agents, they stress about price, and almost none of them ever look at the one document that has the power to stop the sale completely. Sometimes in the final days of escrow and everything else is already done. I'm talking about your title, and what is hiding in it right now might surprise you. According to data from 2025 closings, 42% of title defects discovered during transactions were completely unknown to the seller, not hidden intentionally, not disclosed and ignored, simply unknown. The seller had no idea. And in 36% of real estate transactions, title problems surface at some point during the process. Today, I'm going to walk you through exactly what those problems are, why they are becoming more common in 2026, and most importantly, what you can do about them before they derail your sale. Hi, my name is Rima Rafeh with the Rafeh Group here with eXp Realty, and I've been selling real estate across Santa Clarita Valley, Antelope Valley, and Greater Los Angeles area for over 2 decades, and I have closed over $1 billion in real estate in this market. I've watched transactions collapse in the final week over title issues that could have been identified and resolved months earlier. Today, you're going to know what to look for and how to protect yourself before your home ever goes to market. So let's start with the basics, because I find that many sellers have a general sense of what title means, but do not fully understand what it actually represents and why it matters so much in a sale. Your title is the legal record of your ownership of the property. It's not just a piece of paper, it's a chain, sometimes going back decades or even a century, of every person who has ever owned that property. Every debt that was ever secured against it, every legal claim that was ever recorded on it, and every right that was ever granted to anyone regarding the use of it. When you sell your home, you are not just handing over keys, you are transferring that entire chain of ownership to the new buyer. And if there's anything in that chain that is broken, clouded, disputed, or unresolved, the transfer cannot happen cleanly. And in many cases, it cannot happen at all until the problems are fixed. The process that uncovers these issues is called title search. A title company goes back through the public records, the county recorder's office, court records, tax records, judgment databases, and examines every single document ever recorded against your property. They are looking for anything that affects your ability to transfer clear ownership to a buyer. And in California, this search is a standard part of every single transaction and escrow. What it's finding can change everything about your transaction timeline and your outcome. So let me walk you through the most common title issues that are surfacing in California, Los Angeles area home sales right now, because each one has a different cause and a different solution. The first one is liens. A lien is a legal claim against your property for an unpaid debt. And it's a critical thing to understand about liens in this. They attach to the property, not the person. That means a lien is placed on your home by a contractor who was not paid, by a creditor who got court judgment, by the IRS for unpaid taxes, or perhaps by your HOA for unpaid dues. That lien does not disappear when you sell. It follows the property, and a buyer's lender will not fund the loan on a property with an outstanding lien until it is resolved, period. Now, here is where sellers get blindsided. Many of these liens are old. Some predate your ownership entirely. Maybe contractor placed a mechanical lien against the property 15 years ago when the previous owner did not pay for renovation. Maybe there's an HOA assessment lien from a previous owner that was never properly released. Maybe there is a tax lien from a family member who was briefly on the deed years ago. You did not create these problems. You may have bought the property without knowing they existed, but they are still sitting on your title right now and waiting to surface the minute a title search is run during your escrow. And when they do surface, the clock stops until they are cleared. Mechanics lien deserve special attention because they are one of the fastest growing title complications in California right now. If you had any work done on your home, a renovation, an addition, a new roof, a pool, any significant construction, and the contractor or subcontractor or a material supplier was not fully paid, California law gives them the right to file a mechanics liens against your property. Even if you paid the general contractor in full, even the dispute was between your contractor and the subcontractor never hired and never met. That lien attached to your property and becomes your problem at closing. With the surge in home renovation activity during pandemic years and the contractor payment dispute that followed, particularly as material costs spiked and some projects went over budget or stalled, mechanic liens have become more common in California title searches than they have been in years. If you had significant work done on your home in the last 5 years, this is something you need to investigate before you list. The second major category of title issues is what attorneys call the chain of title problems. All this is becoming dramatically more common in 2026 for a very specific reason. In 2025 alone, nearly 60,000 California homes were transferred through inheritance, representing approximately 18% of all transfers in the state. That is a historic number, and it's a direct result of the demographic wave of aging baby boomers whose estates are now being settled in large numbers. Nationally, a record of 340,000 homes were transferred through inheritance in 12 months through August 2025. So here's the problem that wave of inherited properties is creating. Inheritance transfers often come with a change of title complications that can take months to resolve. An heir who did not sign off on the transfer when the property changed hands years ago, a deed was prepared incorrectly and never properly recorded, a property that passed to an estate without going through the proper probate, or a trust that held the property but whose terms were not properly executed when transferred. An old deed that listed an owner under a name that does not exactly match the name on the current title, which sound minor but creates a legal gap that has to be documented and resolved before a new transfer can be recorded. These problems are not the fault of the current seller. They are the result of transactions that happened years or decades ago without proper legal guidance. But they still in the change of title silently until a title search finds them. And when they are found mid-escrow, resolving them can take weeks or even months, depending on whether heirs need to be located. Title issues in California typically add 2 to 4 weeks in the closing timeline when they are discovered during escrow. And when they are severe, they can delay or derail the transaction entirely. The third category is judgments. If you or anyone who has ever been untitled on your property has ever had a court judgment entered against them, for any reason, that judgment may have been attached to your real property at the time it was recorded. Unpaid credit card debt that went to a judgment, a lawsuit that resulted in a monetary judgment, a divorce settlement with a judgment lien, child support or alimony, areas that generated as a judgment, all of these can attach to real property and all of them show up on your title search. And here's the version that surprises sellers most. A judgment does not have to be yours. It's your spouse or domestic partner, or it was the title that has judgment against them, even from before you were married. That judgment may have attached to the property when they were added to the title. If you remove someone from title years ago through a quitclaim deed, but the judgment was recorded before the removal, it may still be there. Title search, look at every name that ever passed and appeared in the deed and cross-reference these names against judgment databases. What comes back can be genuinely unexpected. The fourth category is easements. An easement is a legal right that someone else has to use a portion of your property for a specific purpose. Utility easements given the power company, the gas company, or the water district the right to access portion of your lot for their infrastructure or access assessments. Giving a neighbor or a third party the right to cross your property to search their own or drainage easement, conservation easement, solar easements in California easement are extremely common, particularly in older neighborhoods and in areas where utility infrastructure has evolved over decades. Most easements are not deal killers on their own, but they can become complications when they are in locations that affect the buyer's plans to the property. An easement that runs through the area where the buyer wanted to build an ADU, for example, or an access easement that affects privacy in a way the buyer finds unacceptable, and when an easement was not properly disclosed early in the process, and when a buyer discovers it mid-escrow rather than before they made the offer, it creates renegotiation conversation that sellers never want to have from a weakened position. The fifth category, and this is one that is getting more attention in California here in 2026 than ever, it's title fraud. Deed fraud and home title theft have increased dramatically in recent years. And they have become more sophisticated, and as a county recorder office have not always had the systems to detect forged documents before they are recorded. In title fraud, a criminal use of forged deed to transfer ownership of your property, sometimes to shell entity, and then attempts to obtain financing against it to sell it before the fraud is discovered. The property owner often does not know it has happened until notice arrives from unfamiliar lender or the property shows up on the market without their knowledge. California and Los Angeles County have been implementing title fraud alert systems that notify property owners when a document is recorded against their property. If your county offers the service, and many in Los Angeles County and surrounding areas do, signing up takes minutes and costs nothing. It's one of the simplest protections available and one of the most underutilized one for homeowners. Now let me talk about the California Preliminary Title Report, because this is the specific document that makes all of the difference between a title problem that stops your sale and a title problem that gets resolved before your sale ever begins. The Preliminary Title Report is a document used by the title company at the beginning of escrow that details every recorded claim, lien, easement, encumbrance, and condition affecting your property's title. It's the title company's way of saying, here's everything we found when we searched the public records. Here's what needs to be resolved before we can issue title insurance and close this transaction. In a standard transaction, the preliminary title report is ordered after you are already in escrow. You have a buyer, you have an accepted offer, the escrow is open, and then the preliminary title report comes back and reveals a lien that's need to be paid off, an heir who needs to sign a document, or a judgment that needs to be resolved. Now you are in a race. The buyer has a rate lock expiring, the buyer has mover scheduled, and everyone wants to close on time. And you are scrambling to resolve title issue that could have been identified and addressed weeks or months earlier if you had simply ordered a preliminary title report before you listed. This is one of the most practical and most underutilized strategies in real estate, ordering your own preliminary title report before your home goes to market. The cost is minimal and the information is invaluable. You find out exactly what's on your title before a buyer does. You have time to address it calmly and methodically rather than under pressure of an open escrow with a closing deadline. And you go to market as a seller who already knows your title is clear, which is a position of confidence and strength rather than uncertainty. Here's the process I walk every seller through before we list. We pull the preliminary title report early. We review it together. If there's an issue, liens, judgment, easement questions, anything that needs to be addressed, we identify them immediately and bring them to the right professionals to resolve them. A real estate attorney for title disputes or their signature requirements, a CPA or tax professional for tax liens, the contractors or their attorney of the mechanic lien disputes, We handle it on a timely manner, not on buyer's escrow deadline. And when the home goes on the market, the title is clean and the transaction can close without surprises. Let me also say something about title insurance because I think it's important for sellers to understand that it does and it does not cover in its context. Title insurance protects the buyer and the buyer's lender against title defects that were not discovered during the title search. It's one-time premium paid at closing that provides coverage for claims that arise after the transaction closes based on issues that existed before it closed. It's an essential protection for buyers and their lenders. What title insurance does not do is make your title problems go away before closing it. If a lien is found during the title search, title insurance does not pay it off for you. If an heir needs to sign document and cannot be located, title insurance does not resolve that. Title insurance is a post-closing protection. It does not replace the pre-closing work of identifying and resolving whatever on your title before your buyer ever gets involved. Here's the bottom line I want every seller in California to hear today. Your title has a history. This history may be completely clean, or it may have something in it that you have no idea about. A lien from a contractor your previous owner did not pay, a judgment from a name on your deed you have not thought about in years, an heir who never properly signed off on a transfer somewhere in the chain. 42% of the title defects found in 2025 closings were unknown to the seller. That is nearly half. You cannot assume your title is clean just because you have never had a problem. You need to know for certain before you list. The sellers who close smoothly, on time, without drama, without last-minute renegotiations, and without buyers threatening to cancel are the sellers who knew what was on that title report before escrow clock started. That preparation does not cost much. It costs less than a delayed closing, a negotiated price, or a collapsed transaction that sends you back to the market with a stagnated listing. If you are thinking about selling here in the Santa Cruz Valley, Antelope Valley, or greater Los Angeles area, I want to have a conversation with you before you list. We will put your title early, review what's there, and make sure that when you go to market, you go with complete confidence that your title is clear and your transaction can close the way it's supposed to. No surprises, no last minute crisis, just a clean, professional sale from start to finish. You can reach me at 661-236-8899. This is Rima Rafeh with the Rafeh Group. And if you like this video, please like, subscribe, and we'll see you on the next one.